of the NEASA. Mr. Tiani, good morning to you and welcome to AM News. Now, why did the Metal and Engineering Industries Bargaining Council ask the Minister of Labour to extend that wage settlement to the whole industry?
Good morning to you, Elvis, and good morning to your viewers. I think I need to give a bit of a background on how the Bargaining Council work and how did we end up in court as the Bargaining Council. One, the Bargaining Council has a responsibility to implement all the decisions that are taken by its parties in its management committee meeting. That's the first thing. Secondly, I think some of you will recall that this has been a long campaign by some of our parties who are of the view that this Bargaining Council is an expensive Bargaining Council in terms of rates that they pay to its employees. And this campaign started in 2011. We've been in and out of court. In 2011 up until last year, we've been in and out of court trying to explain how do you deal with the concerns that are being raised by some of our parties in the form of them being allowed to apply for an exemption. Of course, they have a different view. Their view is that the exemption procedure is not working. The exemption procedure, it only deals with your situation when you are about to close down. We have a different view. Let's come to your question. In 2014, we had new wage negotiations, and that new wage negotiations was signed by 6 unions in our bargaining council, and there are 23 employers' organizations. Out of those 23 employers' organizations, only 2 refused to sign the agreement. Then those who supported the agreement in a management committee discussed the matter and agreed that this particular agreement, it must be extended to all non-parties in the industry.
Why is that?
Because of 2 things. One, you need to make sure that in this particular industry, there is a fair competition. You can't have a situation where there are employers who are paying a certain rate because they happen to be signatory to the agreement, and the rest of other employers who are competing in the same sector are paying less. That does not give you a fair competition. That's one reason. The second reason is that we have been doing this thing all these years. After concluding your negotiations, the Bargaining Council will be asked by parties to go and ask the minister to extend the agreement to the non-parties. We are not doing a new thing. We have been doing what we have been doing all along.
So would you say that your decision was not unlawful?
Look, that's where sometimes we found ourselves in a dilemma, because I don't make decisions. Decisions are made by the parties. And then those decisions, then they become instruction to the office and its general secretary. Then the general secretary and the office will then act accordingly. In this instance, I've said to you there are 6 unions that have signed this agreement. There are 22 employers' organizations that have supported this agreement. And those parties have taken a resolution that the agreement must be extended. And we think we have done everything that needs to be done in terms of our constitution. But of course, on the 4th, these parties, together with our office, will have to give more explanation in court in terms of what have we done, why do we think that everything that we have done is constitutionally and is legal.
Now, the National Employers Association of South Africa, NEASA, claims that the Council and NUMSA conspired against it and steamrolled through these resolutions. Do you think that these allegations are true?
Look, the Council, as I've said, we sit in these meetings, we take minutes, we give guidance where we need to give guidance, and then parties among themselves will have deliberation, will argue, will agree, and they will disagree. At the end of the day, as I've indicated earlier on, when in those discussions emerges a decision, that decision needs to be implemented. I cannot say, as a general secretary of the council, I cannot implement this decision because one party is not happy. When the majority of the parties have taken a decision and no one is disputing that this is now a decision, it might be a decision that you don't like, it might be a decision that you feel is unlawful. But at the end of the day, that decision has to be implemented until it has been changed by the same management committee or changed by law, by the court of law.
Was NEASA part and parcel of these discussions at the point in time?
NEASA have been part of all our discussion. NEASA have been raising their own views in terms of every agenda item that is being discussed. NEASA will agree with some of the issues and they will disagree, sharply disagree with some of the issues. But then at the end of the day, there is a meeting procedure that needs to be followed. When the meeting procedure has been followed and the decision has been made and that decision is against NEASA, that's how things should go forward.
Because NEASA is also alleging that they are refusing to give workers an increase agreed by the Sectors Bargaining Council more than a month ago, claiming that they can't afford it. Do you think that they're being disingenuous in this case?
Look, I don't want to be judgmental on this matter. I just want to say, as the office of the council, we respect the views of NEASA, and we also respect the views and the decision taken by other parties. NEASA, as I've indicated, have been very vocal in terms of making sure that going forward, in their view, the parties should agree to a lesser increase and address the issue of this council being expensive. And they've been given an opportunity to present their views, motivate their views with other parties, try and convince other parties, and trade unions in particular. The fact that they've not succeeded in convincing the union to see things their way, we can't be blamed. The council can't be blamed. But we respect their views. We'll continue implement decisions whether are supported by NEASA or not. If that decision, we'll implement them.
What do you think will happen now with the court case? And what do you think NEASA hopes to achieve with this court application?
You see, there are two things that is going to happen with the court case. One, we are cited as a respondent, as a bargaining council. We need to go there and say to court, these are the things that we have done. We were guided by our constitution when we did the following things. And we think that as the bargaining council, things were done properly. But if this court takes a different decision, this council will abide by that decision. That's one thing that we will do. But the other thing that needs to be done, the parties that took decisions that gave us a mandate to go to the minister and ask the minister to extend this particular agreement have to come to court and argue their case as well in support of what we'll be putting on the table. When I'm saying in support, we're not working with these parties, we're working with all the parties in the bargaining council. But at the end of the day, parties must make their own decision and guide us in terms of how to implement those decisions.
Is the bargaining council and collective bargaining the panacea to all these problems? Because NEASA says that should be abandoned. Your take?
Look, I have always understood NEASA as saying that they are not against collective bargaining in the way, but what they're against is a collective bargaining that is done irresponsible. Irresponsible in the sense that it does not take into account that there are people that cannot afford the increase that is agreed upon. And the system and the procedure that is being followed to address the concern of those people is not appropriate in their view, then it needs to be changed. As and when you decide to sit down and negotiate with them and agree with them on what is defined as responsible collective bargaining, and they agree that we have now reached that point where we're now negotiating responsible and we have responsible collective bargaining, I don't think they'll continue fighting to do away with collective bargaining. But I don't think that is the agenda. I might be wrong, but that's how I've understood them all the time.
Mr. Mtiyana, thank you so much for joining us here on AM News. Now that was Thulani Mtiyana, the General Secretary of the Metal and Engineering Industries Bargaining Council. As you recall, we had that interview with NEASA last week in terms of their grievances. Right.